All right, well, thanks everybody for taking about 40 minutes out of your study session to listen to me today. Hopefully this will be a bit of an interlude from some of the more substantive technical stuff that you're talking about. I was asked to come and talk about professionalism, and maybe more correctly, what happens if we don't focus on professionalism. So as you heard, I'm a lawyer, and I've been working with professionals primarily initially on the defense side, and now more recently on the regulatory college side since about 2008. And so I focus my practice predominantly on acting for professional regulatory bodies like the College of Professional Foresters and the College of Alberta Professional Forest Technologists. So we're going to talk about four things really. What is liability? What kinds of liability should we be concerned about as professionals? How is conduct that can result in those liabilities defined? And what are some strategies that we can keep in the back of our minds to minimize the risks of those liabilities as we go out into the world and practice in our professions? So, there are three big categories of liability, and we're going to talk about two of these today. There's first regulatory and criminal liability. So that would be liability to the people, indirectly through the Crown, either yourselves through breaches of the Criminal Code or breaches of regulatory statutes like the Environmental Protection and Enhancement Act, the Water Act, all kinds of things like that that you will encounter as professionals. There's also professional regulatory liability. And that's where I focus most of my work, is the liability that can result for professionals as a result of their interactions with their own professional regulatory bodies. And then the third big category of liability is, of course, civil liability. So that would be liability by you as to, say, some other person or a company to another company. Those are the kinds of things that are resolved in the civil courts. And that is a topic in and of itself that could take days to talk about. So we're not really going to focus on that here today in our 40 minutes. So, liability can arise in any aspect of your life. And this is a very important concept to bring home to all of the people who practice in regulated professions. So things that you do in your private personal life can result in liability. That would not be a surprising concept to many of us, I would not think. So if I drive after drinking alcohol, I could be charged with a crime, right? If I hurt someone, I could be charged with a crime. If I steal something, I could be charged with a crime. I could also be found liable in the regulatory context. So if I spill a contaminant on the ground, I could be charged under a regulatory statute and punished for that, right? Or there's lots of other things that you'll probably know more about than I do in the environmental context about what kinds of things can get you into trouble. But what might be surprising is that things that happen in your personal private lives can also result in this regulatory liability. So even though you're off work and you're doing things on your own time, by virtue of being a member of one of these regulated professions, you are bound to the code of conduct for that profession and the standards of practice for that profession, and things that you do can get you into trouble. So to give you a quick example, I just got finished with a case on behalf of a regulatory college in the real estate industry. And the issue there was that a regulated member of that industry happened to be out with some people at a bar one night. He was not at work. They may or may not have been clients, so there was a bit of an issue there. But he was drinking, he got into his car, he drove home, and he killed someone. And what do you suppose the regulatory college did about that? Who has an idea? Did they just ignore it and take no interest in it at all because it was on his own personal time? Or did they say, no, that's unprofessional conduct for a member of this profession. We're going to take you through a full contested discipline hearing and we'll take away your license to practice the profession forever? It was the latter, right? They decided it was serious enough for a member of that profession, maybe because we expect people in the real estate industry to drive around and to take clients in the car with them. That's possible. But they decided it was serious enough to take away his license to practice forever. So things that you do in your personal and private life can engage your obligations under these codes of ethics, these standards of practice, and can result in serious ramifications. I'm not saying either of the colleges are going to do that. I don't know, but it's just important to understand that as a member of a profession, it means something to sign on to these codes of ethics and these standards of practice. So, we're going to focus the first part of our discussion today on what does it mean to be a professional, and when you sign off on things, what are you exposing yourself to in terms of potential liabilities? So we're going to talk first about specialist sign-off. Specialist sign-off is an example of one of these areas where through your practice you engage with these very regulated areas and you can get yourself into trouble. It's an example of an area in which there are detailed standards of practice that you need to be aware of. So what is specialist sign-off? Well, before we really get into that, I want to pause and talk about a trend in the professional regulatory world called professional reliance. So I first became aware of this trend when I was doing some research for another presentation, and in the 1990s, it seems, in the forestry industry in British Columbia, the Ministry of Forests began to rely more on consulting professionals than their own civil servants to make decisions, provide assurances, and sign off on things. So it allowed the civil service to unload some of the responsibility on their people onto consulting professionals in the industry. That trend has expanded, and we have examples of it all across the country now. So in Alberta, since 2007, and really since January 1st, 2008, there are 7 professional regulatory organizations, or PROs, whose members can practice in reclamation and remediation work. Of course, the College of Professional Foresters and the College of Professional Forest Technologists are 2 of those professional regulatory organizations. So as you get out into practice, once you've been doing it for a few years, and you meet some criteria, you can do reclamation and remediation work, which no doubt many of you will have thought about already. Oops. And you can complete professional declarations for reclamation certificates if you satisfy those criteria, which are, got ahead of myself a little bit, on this slide. Okay, these are just paraphrased. So if you've been out for 5 years and you satisfy the competencies that your college requires and they sign off on you doing it and you're authorized by your employer or your client to do it and all these other things you're prepared to do, you can do reclamation and remediation work, including signing off on the applications, right, for reclamation and remediation certificates. It's important to understand that the ability to do that, and the detailed practice standard we're going to talk about in a little bit, does not replace the other obligations that you will have as members of one of these regulated professions. So there are existing laws you'll have to comply with. There are policies like the Code of Ethics. There are criteria, et cetera, that you will all have to manage. But there is this joint practice standard that has been developed for reclamation and remediation work. So what is this sign-off thing? What do we mean when we say we're going to sign off on a reclamation application? Or what does it mean when I sign off on anything as a forester or a forest technologist? It means you're taking professional responsibility for the information in that application. It's a warranty that other people can rely on. The government of Alberta will rely on it, but subsequent landowners will also rely on it. Third parties will rely on it. All kinds of people will rely on it to be sure that you have exercised your professional judgment in an appropriate way. It also means that you're accountable if there are any errors in that application. So specialist sign-off on a reclamation application is just an example of your professional practice. Whether we're talking about specialist sign-off on a reclamation application or just about practice generally, the principles for our purposes today are the same. Your practice can get you into trouble, and there is a risk of liability that arises whenever we're doing something in our professional practices. And so we're going to talk a little bit more about the types of ways that can happen, and we're going to end with some strategies and tips to try to minimize that risk and avoid it altogether if possible. So what are some sources of those liabilities? Well, there are many, but these are some of the big ones, right? So I mentioned the Environmental Protection and Enhancement Act, the Criminal Code of Canada, the Water Act, and I'm sure you can all think of others. Let's look at the EPEA as an example. So one of the things, it's a very dense, complicated statute, but one of the things that's in there is an offense provision. And it says that the offenses that you might commit, and I don't mean to bring this up to scare you all, but it's important to understand that there are these things that you have to be aware of, right? So one of the things in the EPEA is an offense provision that says you commit an offense if you provide any false or misleading information. So if you were to be submitting an application and you signed it and it turned out that any of the information in that application was false or misleading, you could, right, be committing an offense under the Environmental Protection and Enhancement Act. If you contravene something that you're supposed to do under an order or a certificate under one of those pieces of legislation, you might be committing an offense. Right? So, okay, well, that's fine. What does that mean, right? What's an offense? What is that going to mean for me? Well, it can be very serious. So if you commit an offense under the Environmental Protection and Enhancement Act, for example, as an individual, you can be on the hook for up to $50,000. If you're a corporation, and of course many of you will work for corporations or you'll have your own corporations, you can be liable for up to $100,000. Half $500,000, sorry. And it's also important to understand that if you're practicing through a corporation, what the legislation, this legislation and many others say as well, is that the directors and officers of those corporations are on the hook too, right? So you cannot necessarily insulate yourself from this kind of regulatory liability just by sheltering yourself behind a corporation. If you do something knowingly, or if a corporation does something knowingly, it's a whole lot worse. And knowing means that the directors or officers of a corporation or you as an individual have some element of intention for what you're doing. You might not directly intend to cause harm or to breach one of these things, but if you have some degree of knowledge and you go forward anyway, you can be on the hook for a whole lot more. Right? So bottom line, if you have an inkling in your mind that something you might do might be wrong, don't do that. Back up and make sure you're doing it the appropriate way. What else can EPEA offenses result in? Well, there's other things than mere fines, right? You can have environmental enforcement orders, you can shut down projects, you can cancel reclamation certificates, all kinds of very serious ramifications that are not going to be very good and that no doubt we would like to avoid. So that's an example of regulatory liability. What about criminal liability? This is an example. Okay, if you are found to have used false or misleading information somewhere to obtain a benefit for you or for someone else, well, that's fraud. And if you commit fraud, obviously you can be charged criminally. You might be charged as an individual, or a company that you work for or through could be charged criminally with fraud. And we want to avoid that too. Right? So that's an example of criminal liability that can result. Now I want to illustrate for you what's called the onus and standard of proof. And I'm going to differentiate the onus and standard of proof in these regulatory or criminal types of proceedings versus the onus and standard of proof that we're going to see in professional regulatory types of proceedings, because you're going to see that they are different. Right? Who's watched Law and Order? Okay, so what is the standard of proof that they always talk about on Law and Order? What do you have to prove? Beyond a reasonable doubt, somebody said, right? That's right, it's beyond a reasonable doubt. So in Canada, in criminal law or regulatory law, the onus of proof is on the Crown. They have to prove everything, and they have to prove it beyond a reasonable doubt. And what that means is that if you can come up with a defense that has this shred of reality to it, like we use the phrase air of credibility, if you can come up with a shred of a defense, you probably won't be convicted, right? Because you can't convict somebody unless you can prove they did it beyond a reasonable doubt. So at all stages, the onus of proof is on the Crown, and the standard of proof is very high beyond a reasonable doubt. Now let's talk about professional regulatory liability. That's the kinds of proceedings you can find yourself in as a result of things that you do in your professional practice and that the colleges will bring if they receive complaints or if they are concerned about something that you've done. So what are the sources of those kinds of liability? Well, there's the Regulated Forestry Profession Act. We've all read that cover to cover, right? Right? There's the Registered Professional Foresters Regulation. Again, I'm sure it's beside your bedside. There's the Registered Professional Forest Technologist Regulation. So each profession has its own regulation with one umbrella act that governs both, right? And then there's the Code of Ethics, Practice Standards, and the Joint Practice Standard, for example, for each profession. So those are some of the sources of professional regulatory liability. But what do we mean when we talk about professional regulatory liability? How would we do that? Is it like breaching the Environmental Protection and Enhancement Act, or is it something else? Well, it's defined in the Regulated Forestry Profession Act, what we're talking about. It's a definition called unprofessional conduct. And as you can see, unprofessional conduct is a very broad concept. So it's a lack of knowledge, skill, or judgment in the provision of professional services. If you do something that demonstrates you didn't exercise skill or judgment in your professional capacity, that can be unprofessional conduct. If you contravene the Regulated Forestry Profession Act, the Code of Ethics or Standards of Practice, that could be unprofessional conduct and result in liability. If you contravene any other enactment that applies to your profession, that could be unprofessional conduct. So any other enactment means any other act. So that would be the Criminal Code. That would be the Environmental Protection and Enhancement Act. It would be the Water Act. It would be any other act or regulation that you can think of that in any way intersperses with your professional practice day to day. It could be failing to comply with the continuing competence requirements that the college requires you to do. That could be unprofessional. And then there's what's called, in my world, fancy technical term, a catch-all, right? Anything that harms the integrity of the profession can also be unprofessional conduct. So you need to keep in mind that as a forester or a forest technologist, you are a representative of these professions. And if you do something that brings disrepute on the profession or harms its integrity in a general way, that can be unprofessional conduct. I have some examples from the Codes of Ethics, which we have all read cover to cover, right? Of course. The Code of Ethics for the College of Professional Foresters is 15 pages long. And you should actually read it. Right? I realize you have a few other things you're studying for right now, but you should read it because it's important to know what's in there because you are held to it when you become a member of the college. So here's 3 examples that are in there, right? You have to ensure all forest management plans you sign off on comply with the law. Not earth-shattering. You have to advise your employer or a client of the consequences of any contemplated course of action which, in your opinion, is not based on sound practices. That's a pretty serious obligation, right? And you might think, especially in this economy, of situations where people might be reluctant to start doing that, right? But it's an obligation you have as a professional because this is more than just an employee-employer relationship that you're getting into. You are a professional, and that is more important than the relationship you have with your client or with your employer. And you can only sign documents, plans, or work that you've prepared or carried out or which have been prepared or carried out under your direct supervision or review. So remember, these are just 3 of the things in that 15-page document which you should be aware of. CAPFT has its own code of ethics, and it's a bit shorter. There's 15 ethical principles. But there are a lot of similarities in those documents. So you'll see, when you look at those ones on the slide, that they pretty closely mirror a lot of the things in the other Code of Ethics for the College of Foresters. So this is an example of some text from that joint practice standard for reclamation and remediation work I wanted to point out to you. And I wanted to point it out to you because It's explaining that the joint practice standard also defines misconduct and unskilled practice to some degree. Right? So even though there are those definitions of unprofessional conduct that I showed you, you have to be alive to these codes of ethics, and you have to be alive to these standards of practice. And if you're practicing in one of these areas, it's important to have these things in mind, because if you breach them, that can give rise to liability. Yet another example from the joint practice standard. Okay? It talks about if you're doing rec rem work as an example, and we're only using this as an example, and you don't make sure that you have well-developed objectives, scopes, and responsibilities, appropriate data quality objectives, a process for scope changes and progress milestones, et cetera, you can be found to have breached the practice standard, and that might be unprofessional conduct. Right? So this is all to illustrate that codes of ethics are important. Practice standards are important. And if you don't read them and commit them to memory, you can be found liable for things. What do we mean when we say liability? What are you talking about, professional regulatory liability? What can happen to me, right? Well, there are a whole panoply of things that can happen. They range from not so serious things like a caution or a warning. They range all the way up to the most serious thing, which would be you are no longer a member of the college, right? You're out. And you will have a very difficult time becoming a member of any other college in Canada because we will tell them we kicked you out. There can also be fines up to $25,000 per hearing, and there can be costs, right? If you are found to have committed unprofessional conduct and it's necessary to have a hearing to determine that, you can be held responsible for the costs of the investigation and the hearing, which can be a whole lot more than $25,000. I have a dentist's file right now. The costs for the dentist, one-day hearing, $40,000. So, now remember I said we wanted to compare the onus and the standard of proof in professional regulatory proceedings to the onus and standard of proof that apply in regulatory and criminal proceedings, because they are different. The onus of proof, in other words, who has to prove things, is still on the people bringing the allegations. It's still on the college. This is this role called the complaints director at the college, whose job it is to prove if they say you've committed unprofessional conduct, they have to prove that. But the standard is different. The standard is called balance of probabilities, and it is lower than beyond a reasonable doubt. How do you defend your professional practice if you are ever accused of doing something unprofessional, right? It's not enough to show that you met the expected standard for an RPF or an RPFT. You have to be able to prove and show your work that you met the standard for an RPF or an RPFT. You have to be able to explain why you chose a particular methodology. You have to be able to demonstrate that you applied the analysis that you were supposed to apply. You can't just have the conclusion, or we won't know how you got there, right? It sounds pretty simple. You're going back to grade 5 math. You have to show your work, right? And I know that sounds overly simplistic, but it is really, really important when someone like me is looking at your practice and saying, is there anything unprofessional they did here? If I can see that you showed your work, well, it's probably going to be a whole lot easier to defend that you did a reasonable job coming to that conclusion. So the joint practice standard, and I won't read this to you, but just so that you're aware, it does seem overly simplistic to talk about good working papers and reports, but it actually says in the joint practice standard, you have to have good working papers and reports. I want to give you a little anecdote example from my own practice, which I think illustrates this principle. So I had a case a few years ago where I was working for a regulatory body that deals with engineers. And we were dealing with a case where the accusation was that an engineer had taken on an assignment, done an inadequate analysis, and generated an opinion that was unreliable. And we said that was unprofessional. So he accepted a retainer to assess the integrity of a concrete slab foundation, essentially a concrete floor in a building. And what he did was take some core samples, measure the compressive strength of those core samples, compare that to the weight that the expected load would put on the concrete, and he said, oh, one-page report, there's no problem because the compressive strength of the concrete is higher than the weight of the load. It was a truck. There was nothing else in the report, and he actually said he didn't do any other analysis. This is, in essence, what his report said. It's not exactly the same, but it's in essence the same thing. He said, I was asked to do this analysis. I took the core samples. I determined the compressive strength. I compared them. The compressive strength was higher. Therefore, there's no problem. And I didn't do any other analysis in my report. As an aside, he also showed up at the hearing and said, oh, actually, I did a whole bunch of other analysis. I used a computer model, and I talked to a structural engineering friend of mine. And so don't worry about it. Everything's good. What do you suppose the discipline committee of that regulatory body did with that? They said he was lying. He was lying, and they found him guilty of unprofessional conduct. Now look at this, right? This is not a real report, but this contains the kinds of things that your reports should all contain, right? So there's not just the purpose, the results, and the conclusion, but there's also the methods. There's also references to the literature that the person relied on. There are limitations stated for the conclusion. Which of these two reports, the first one or this one, do you think it would be easier to defend if you were accused of unprofessional conduct? This one, right? Okay. So this slide just talks about something called the due diligence defense. The idea behind this is that a lot of the regulatory offenses that exist out there in the world that you might find yourself accused of are what are called strict liability offenses. And that means that there's no element of intention required to prove them. What that means is that if you can show that you exercised due diligence in trying to do your job properly, it's a whole lot easier to defend you. Document retention. A lot of time and energy is spent on document retention policies in organizations. You'll see them probably when you get into practice if you're not already out there doing it and seeing it. Large organizations have complicated document retention policies, but smaller organizations should have them too, right? Ideally, all notes, all working papers, all data should all be recorded and stored for as long as possible, right? Ideally, they would all be recorded electronically and saved in a document management system that you could access forever. However, we realize it's not always practical to do that. The joint practice standard, and I bring this up again because it's an example of a standard of practice you should be aware of, actually says that you have to retain copies of all your review files for at least 10 years, because that is what the limitations law in Alberta says. 10 years would be the ultimate limitation period for bringing lawsuits in Alberta. In reality, you should keep them for at least 11 years, because there's this weird thing where you can file a lawsuit in Alberta and then wait a year before giving it to somebody. But 11 years is only for civil litigation. It's important to understand that as a member of a professional regulated profession like these two, there is no time limit on when claims can be brought or professional regulatory proceedings can be brought. You could receive a complaint about something that you did more than 11 years ago, and the college will have jurisdiction to look into it. So document retention is very important. Now, what is the one thing I haven't really mentioned yet on document retention that I alluded to earlier? Email, right? It's incredibly important. If you're anything like me, almost everything that you do in your practice is documented on email. And those email chains are a challenge to retain. But it is important to be able to pull out those email chains and to be able to show the chain of correspondence that resulted on a particular file at any point in the future. So if you're not already in the habit of filing your email in a folder and making sure that those emails don't get deleted at some point, you should do that. Written contracts are a challenge because you're not always in a position to negotiate exactly what you want to go in a written contract. Ideally, a written contract between you and your employer or you and your client will include some key things like who's going to do the work, who's going to pay for the work, how much are they going to pay, and what work is going to be done and when, right? Those are the main things. But it would also be really important for those contracts to have some reference to professional responsibilities, right? It would be really helpful if that contract contained some assurances that as a professional, you will be entitled to use your professional judgment. And you'll be entitled to tell your employer when your professional judgment differs from what they might want to do. That will be an important clause if we ever, hopefully we never would, were in a situation where you were in some kind of dispute with your employer. They were saying you're not being a good employee by sticking to your guns and talking about these professional obligations all the time. Again, the practice standard actually talks about written contracts. So here's an example of a practice standard that would apply if you're doing reclamation and remediation work that actually says you have to have these written contracts. And it has to talk about the objectives of the project. It has to talk about terms and reference and scope of services. It has to talk about insurance. Who's got the insurance? Somebody has to have the insurance, right? It talks about that you may disagree with the conclusions and the materials to be reviewed, and this may necessitate additional work, right? So there's an example. It's important for your contract to say you might disagree with your client or your employer. And this is another example from the Joint Practice Standard. It actually says you should complete a written agreement with the coordinating professional, that would be the person overseeing the whole reclamation project if it's not you, confirming what you're going to do, how much you're going to be paid, and the timing of those services. So if you don't have a written agreement in place, what's the problem? Any ideas? One problem would be you're breaching the practice standard because you don't have the written agreement that it says you have to have, right? So that could be unprofessional conduct. Another problem would be there's no clarity on those terms. Who's doing the work? Who's paying for it? How much are they paying? And when is it going to be done? And can I say, in my professional judgment, we are not doing this the right way and you need to listen to me? Those are very important things for you to spell out in your relationships with your clients and your employers.